Freedom of expression has been a right that is constantly challenged in Sri Lanka for the past few decades. But the voice that is raised against it is mostly of journalists, activists, and some minorities. But right now, freedom of expression has gained the spotlight of wider public. Many are talking about freedom of expression, but do we really know what entails it? What are the other rights that are interlinked with it? What are the remedies that we can take if it gets violated? To serve this purpose, we have initiated a series of discussions with the experts in the area called Janamathayata Vedikawa. From today's episode, we have Ms. Kishali Pinto Jayawardena joining with us. She graduated with honours from Faculty of Law, University of Colombo in 1993. Since her enrollment as an attorney at law in 1995, she has appeared for several landmark cases in freedom of expression. Legal editorial consultant of Sunday Times since 2000, she writes the column focused on rights for the newspaper. She's a legal analyst and an academic specialized in right to information with a number of publications on the matter. She served on the Right to Information Commission from 2017 to 2021 as a nominee of the Editors Guild and currently serves as a nominee of the Bar Association of Sri Lanka. Ms. Kishali, we warmly welcome you to the program. My first question is, how would you describe the importance of freedom of expression in the Constitution of Sri Lanka, and how essential is right to information along with it?
So basically, the right to information and the right to freedom of speech and expression are essential for a healthy democracy to function in terms of the right of citizens and the ability of citizens to know about who is governing them, what decisions are taken in their interests, and basically how the process of governance works. So I would say that this is a fundamental part of representative democracy. Essentially what we mean by representative democracy is the government by the people, of the people, and for the people. So it is only if you can make informed decisions about how you are governed, only if you have the information about how you are governed, that you are able to elect those who will represent you properly into seats of government. Without that knowledge and without the ability to criticize and to express your views about who is governing you, citizens become like sheep in a democracy. So these rights are linked, right to information and right to freedom of expression. They are very important. I would say they are co-rights in a way to a functioning democratic process. So if you look at, for example, the difference between states we refer to as liberal democracies and states we refer to as fragile states. This core difference hinges on the right to information and the right to freedom of speech and expression not being there in fragile states. In fragile states, the characteristic feature is that governments clamp down on those who are exercising the right to freedom of expression. They don't like to be criticized, they don't like dissent to be expressed. What they want is a full freedom and a full discretion to do what they want with the public funds, with the public power, and they don't want any criticism or critical scrutiny of their actions by the people. Now, in liberal democracies, a very fundamental feature is that the right to criticize not only political leaders, but also even judges, for example, and judgments. These are all part of a healthy democratic process and a way of life. It is not something extraordinary or something strange that one has to fight for, like in the case in Sri Lanka, where we had to fight for certain rights for many years. In many countries in the world, these rights are not given to you by politicians or by political leaders. They are not privileges. And that is where the importance of a right comes in, because a right means that you are intrinsically, inherently able to exercise that right without somebody giving it to you as a gift or as a privilege or as some, something to be done as a magnanimous gesture. Very often politicians in Sri Lanka say, oh, we are letting the people express dissent. It is not a question of politicians allowing people to express dissent. People have the right to dissent by virtue of being citizens of Sri Lanka. That is the compact that they enter into with a government when a government is elected to seats of power. Without that component, without that freedom, a government should not be able to govern. They should lose the legitimacy to govern if they do not have that right.
Can you explain the scope of freedom of expression that is guaranteed in the Constitution of Sri Lanka, what it includes and what not, in some key aspects?
So, as many I think would know, right to expression and freedom of speech and expression comes in Article 14A of the Sri Lankan Constitution, and that has been with us since 1978. In very simple terms, it gives a citizen the right to express one's thoughts and to in a way to use that right to participate in government. Okay. So, that is in simple terms, but throughout the years from 78 to right now, particularly during 1990s, the late 1990s up to maybe mid 2000, the Supreme Court interpreted many of this particular right in a way that expanded parameters of the right. So, for example, the Supreme Court said that the right to express one's opinion and one's freedom of speech extends to criticism of the government. It extends to even forceful overthrow of a government, provided it is advocated peacefully. So, the distinction here is that you have the right to dissent, you have the right to criticize, but it must not incite violence. It must not be an incitement to violence. So, that is where the boundaries of freedom of speech in a sense could be defined. But within those boundaries, you have a very strong right to be able to express yourself in various ways. In interpreting that right, the court has actually held in many instances that emergency law, for example, cannot circumscribe or cannot prohibit or restrict the right to freedom of expression beyond reasonable means. So, for example, you have the right to protest, you have the right to get together with others, 10, 15, 20, hundreds even, to get on the streets and say you are objecting to a particular government policy. You have the right to even criticize a president or a prime minister in a very strong terms. And that is all part of the right of freedom of speech and expression. Where right to information was concerned, of course, we did not have it as part of the constitutional framework at the start. So, what the Supreme Court did in the early years was to bring in the right to information as part of the freedom of speech and expression, impliedly, right? But in many decisions, but that was felt not to be enough. So, we fought for more than 14 years for the specific right to information to be brought into the constitutional framework. So, in 2016, we had the Right to Information Act of Sri Lanka, which has been globally ranked as one of the best laws in the world, both in theory and in practice. Before that, in 2015, you had the 19th Amendment to the Constitution, which brought in the constitutional right to information in a specific sense. These what can I say, these aspects of the right to information, right to freedom of speech and expression are brought together by the constitutional provisions as well as by statutory provisions. So, it is very strong in Sri Lanka in theory. Now, in practice, of course, there have been many problems in the way right to information and right to expression and freedom of speech is where citizens are perhaps being stopped or prevented from exercising certain rights in that way. But at least in theory, our rights, we have a very strong structure in terms of the rights provisions. So, constitutionally also the freedom of speech and expression can be restricted in certain ways, in certain, for example, national security, but all that must be prescribed by law. So, by prescribed by law means that a law must state the restrictions in clear terms. A president, a prime minister, minister or a politician cannot all of a sudden say, oh, today I am waking up and I am going to say that it can be restricted to this extent. No, their wishes or their statements have no legal impact. It is the constitution and the statute which prescribes the way that rights can be restricted.
As you also spoke about the RTI Act and what is guaranteed in the Constitution, what are the key differences in these two, having these two aspects, and how are they interlinked?
So, The right to information in Article 14, 1A of the Constitution, brought in through the 19th Amendment to the Constitution and continued through the 20th Amendment, talks of the right to information being available only against state or government authorities, right? It is also restricted by certain grounds that are different to the Right to Information Act. For example, in the Constitution, you can restrict the right to information on the ground of protection of health or morals and reputation of and rights of others. Now, these are rather vague terms. So, for example, what do you mean by morals, right? Moral, what is moral may mean something to me, may mean something to you differently, and may mean something to another person differently, right? So, rights and reputations of others, these are all rather general terms. Now, in the Right to Information Act, which we campaigned for and struggled for 14 years in a way to bring about in Sri Lanka, and it was unanimously passed in Parliament in 2016, the right to information is restricted on very specific 14 grounds, which do not include health or morals. It includes very limited, narrow exemptions. For example, the right to privacy, right? So, a citizen has a right to use the Right to Information Act to go to a public authority. A public authority would mean not only government authority, but also in a sense even corporate authorities and non-governmental authorities within certain limitations. Unlike the Constitution, which does not allow a citizen to go against corporate entities, or it has to be against government entities only. So, under the Right to Information Act, the citizen can very simply file a request for information from either a governmental or a non-state or a non-governmental organization asking for information, and the essential fundamental theme of the Act is that you must give the information. That is what you mean by the principle of proactive disclosure. The maximum disclosure principle, that is, public authorities must, and we define all these entities that are covered by the Act to be public authorities. So, public authorities must give information in all instances except in those very narrowly defined 14 grounds. So, for example, if you are asking for information from public authority and that information relates to the medical records of another person, that would be a problem because that is defined as an exemption in the Right to Information law. Or again, you are asking for certain private details of a person, where he or she went to, whom he or she met at a particular point. These are construed as private details of a person. So, the public authority can refuse to give the information in those instances. Again, national security is a ground that is common to both the Constitution and the RTI Act. You can refuse information on the grounds of national security, but where the Right to Information Commission is concerned, we have defined national security to mean very specific instances where the security of the state is under threat. So, for example, if it relates to procurement issues, how a state accepts tenders for the supply or the bringing in of certain items to Sri Lanka, relating to the maybe the armed forces, that is a procurement issue. That is not a national security issue. So, in terms of a tender procedure, for example, not the details perhaps of what is procured, but how the process is followed. Is the government following transparent processes of procurement and tender procedures in acting in this manner? So, those are matters that under the Right to Information law, the Commission has also upheld requests by citizens to allow the information release.
Could you describe how governments curtail freedom of expression, especially in the Sri Lankan context, and how it affects the democracy, and how can the civil society actors deal with it?
So, it is very clear in Sri Lanka how governments restrict freedom of speech and expression. We have had very good examples before us for the last so many months and for the last so many decades as well. What is happening now in Sri Lanka in terms of the young people getting out the streets, protesting, the enormous surge of public anger that we see is not it's not a manifestation or occurrence that is peculiar to the current period or the current months. We have had these protests, these expressions of anger and dissent almost the entire period of a post-independence history. These have defined Sri Lanka, you know, as much as conflict has defined Sri Lanka, whether we are talking about the northern conflict or the southern conflict. We have had southern conflict in Sri Lanka in the 1970s and the 1980s, where thousands of young Sinhalese people died. Sinhalese youth died. We have had the northern conflict since the 1970s, where thousands of Tamil youth died. So, protest and dissent and conflict has defined democracy in Sri Lanka. So, the state has used very specific weapons to repress citizens throughout the last 40, 50 years. First, it has allowed the constitutional provisions to operate in a vacuum, in isolation. So, you may have, for example, certain instances where the Supreme Court will rule on a particular violation of rights and say this is wrong, but the state in its response thereto has never changed state policy in regard to freedom of expression or speech. So, what it has done is it has given relief only in that one instance, but in every other instance it has continued to repress. So, for example, if the Supreme Court gives an order in a particular case saying that demonstrators should be allowed to you know, demonstrate properly, they should not be, police should not be able to arrest them. In that particular case, the government has no option but to say yes to the Supreme Court, because otherwise they will be, they could be held in contempt of court. So, they will say yes and they will let that order be implemented, but they will not change the way of repression of citizens' right to protest. So, we saw what is happening now in the same way we saw this happening in the 1980s, you know, where the court, for example, gave many judgments that would uphold the rights of protesters. But that did not stop the police from intimidating protesters, arresting them, beating them, assaulting them, purely for the sake, for the act of protesting, for the act of getting on to the streets, holding a placard and saying, I don't agree with what is happening, you know. So, that we see currently also happening quite a lot. And the second method that the government has used, and when I say government, I mean all governments. It's a very important point, because in Sri Lanka, this has been the state that has been violent. So, often we go wrong because we interpret it and we apply it to a particular political family or a particular government. We say this family is bad, that government is bad. It is not necessarily a family or a government. It is the state and the political establishment that has acted always through violence in responding to the legitimate dissent of citizens. And the fact of that particular pattern is why Sri Lanka is currently in a position where it has virtually become a bankrupt country, where we have you know, serious food shortages, serious essential supply shortages. Why? Because when a state practices repression against the citizens and the citizens are not allowed to express their voice in the matters of government, essentially government itself comes crashing down. So, Sri Lanka is a very classic example of the situation. So, Sri Lanka has used emergency law since the 1980s to repress citizens. And emergency law has been used by the police, and sometimes even the courts have upheld emergency law to say that when conflict is happening in Sri Lanka, or there is some kind of a civil law, even a war-like situation, rights don't really exist. So, that has been one view held by even certain judges themselves, though a lot of other judges have expressed different views. Certain judges have also said no, but we must not exercise rights when there is conflict. So, these are, you know, sort of in a way gaps or faults in the manner in which we have allowed the expression of rights in the country. So, we see that happening now. We see many instances of young people being arrested, young people being thrown into jail for reasons of you know, purely getting together in a crowd and protesting. You know, sometimes when somebody is arrested, they are not given the reasons why they are arrested, you know. So, one significant way, and I will talk about this a little bit later as well, that this state repression has been responded to is by the citizens themselves coming together in a very unified way, including lawyers, including other professionals, and standing up as one active voice and telling the government, you must stop this, you know. That also we have seen. So, on the one hand you get the repression, on the other hand you get civic response. And that is a very positive sign for Sri Lanka at the moment.
As you spoke about judicial activism throughout the discussion, can you briefly pinpoint some of the landmark cases in this freedom of expression arena, and what does it mean for civil activists and journalists and anyone who is active in this freedom of expression?
So one of the most notable cases that we talk about is a case known as the Janakosha Case, in which none other than the former Prime Minister Mahinda Rajapaksa, when he was a member of the opposition at the time, protested against the United National Party by he and along with hundreds of others, Sri Lanka Freedom Party activists and workers, party workers, they clashed pots and pans and who tooted their horns, and it was a noise protest that is called a Janakosha. And when they were arrested, when the government tried to stop them at the time, the court responding to that fundamental rights action brought by the opposition parliamentarians said that no, that Sri Lankan citizens have the right to exhibit their dissent against the government, whether it may be through speaking or whether it may be through making of noise. Now, recently also we saw in the last 2-3 years, for example, when politicians went by in their vehicles, in their motor cars, citizens tooting their horns in protest. We saw many expressions of dissent in this way, and these are all have been held to be constitutional by the Supreme Court. In many, I mean, the cases are far too many to mention, but in many other cases, for example, the courts have consistently held that demonstrators cannot be arrested, cannot be imprisoned for merely exhibiting or showing peaceful dissent with the government, even a strong or forceful dissent against the government. There were instances where the court has emphasized the importance of independent body regulating the media. For example, in the 1990s, there was a body sought to be set up by the government to regulate broadcast media called Broadcasting Authority, Sri Lanka Broadcasting Authority, and that was challenged the Supreme Court, and then the court held that if you want to regulate the media, if you want to regulate the electronic media, you must have an authority or a body that is independent of government. You cannot have a political body that is subservient or subordinate to the government. There is only the minister's appointments in that authority to determine how to regulate the broadcasting sector in Sri Lanka. So the court has, I think, responded quite well during a particular period, 1990s to 2000, in upholding the citizens' rights to expression, information, speech. But the last 1.5 decades, we have seen a notable decrease in the court's intervention in protecting citizens forcefully like it did earlier. And that, I think, is a pity. That should be changed because the judiciary has to stand up as the guardian of constitutional rights in Sri Lanka.
Thank you very much, Ms. Kishali, for joining with us today with that very informative discussion. I'm sure the audience learned a lot through today's discussion. We'll join again with you with another episode on freedom of expression. Thank you.